My name is Ben Williams. I'm a Texas broker in El Paso, Texas. I run a team called the War Team, and we are doing the deep dive into the 1 to 4 family residential contract. And I do this in increments. So I'm going to do page 4 through 6, but let's jump into 1 to 4 family, pages 4 through 6. All right. At the top of page 4, there's going to be the beginning of additional title notices. Let's start off with the tidewater. If you have coastal properties, these are notices go with that. Next is the annexations. Property outside city limits may later be annexed. So if you have properties that you're dealing with outside city limits, that could happen, and it's just letting the buyer know that is capable of happening. Number 6 is the property located in a certificate service area of utility service provider. Simply put, extra costs / delays possible for water and sewer hookups. 7, talk about PIDs. If the property is in a PID, seller must give the buyer written notice as required by the property code if it is in a PID. And number 8, transfer fees. If the property is subject to any private transfer fees obligations based on the property code, the private transfer obligation may be covered by Chapter 5, but it must be disclosed if there are transfer fees. And then number 9 is any propane gas systems, notice required if served by a propane distribution retailer. PIDs are your biggest cautions here. They're easily missed. Please check out your public improvement districts and all of the things that goes with that. When you do this, be careful of PIDs because the seller has to give written notice to the buyer before they close on this property if they are in a PID. Let's go to paragraph 6E, 10 through 11. Simply put, more notices, water level fluctuations, number 10, and then number 11, which mold remediation. If the property was ever professionally remediated from mold, then as a seller, you have to give that buyer the results of that, the certificate, and it must be within the last 5 years. So if anything's ever been remediated from mold, then has to be given to the buyer, the certificate, if it was done within the last 5 years. Let's go to 7 alpha, property condition. This is where the buyer gets to look before they buy. You have to give the buyer access in reasonable times, and this allows the buyer to come in and do inspections by higher Trek inspectors. Hydrostatic testing requires that the seller has written authorization. And it says here, 7 alpha, that the seller must turn on and keep on utilities at the seller's expense during the contract. And they say during the contract, particularly they say that just because they know contracts are moved to the right, get extended, stuff like that. So if a contracts get extended, it does not take away the obligation of having the utilities turned on, right? You don't want to get in those situations where you're doing a buyer walkthrough and the utilities are off and you're like, okay, why are the utilities off? And you're the buyer's agent and they're looking at you all crazy. The seller is supposed to keep the utilities on during the contract, plain and simple. Let's talk about 7B, seller's disclosure. All right, seller's disclosure notice, if there's 3 different options here. All right, 3 options. Option 1, meaning nothing more to do, the buyer has received the seller's disclosure. Option 2, buyer has not received the seller's disclosure, and within the time allotted, within the contract, in this case 3 days, they're going to receive it. If it's never delivered, buyer can terminate at any time before closing. If delivered after you've entered in the contract, the buyer has additional 7 days to terminate for any reason once it is delivered. Now, I want to specify, meaning that you went under contract, there was a need for seller's disclosure, you did not receive it at the time of execution, and then when you do receive it, the buyer has additional 7 days, regardless of whenever they received it, to terminate the contract. All right, so keep that in mind. That is something that a lot of people miss. And then number 3 is they're exempt for the Texas property code to actually have a seller's disclosure. All right. So keep that in mind on 7B. 7C, lead-based paint 7C. If it's built before 1978, it's telling you, hey, we have to have a lead-based paint addendum is required by federal law. 7D, acceptance, meaning as is, means present condition, defects and all, except for title warranties. Now, accepting as is does not stop the buyer from doing inspections, negotiating repairs, or terminating during the option period. It does not do that. As is must be one of those things that you explain to particular buyers, because a lot of times they're going to want you to put certain things like subject to inspections and stuff like that, which is not what's supposed to be there, which is in 7D, which is the next one, 7D2. It really reads there. If you say, okay, check one box, A, accept as it is, or 2, buyer accept the property as is, provided the seller at seller's expense shall complete the following repairs and treatments. And it says at the bottom, to read there, do not insert general phrases such as subject to repairs that do not identify specific repairs or treatments. So what you're looking at, something like there, hey, maybe the rock wall was turned or tore down, or one of the doors was missing or something like that. If there was things of that nature, latent defects that you say, hey, the buyer is saying, hey, I will not buy this unless this happens, then those types of items goes in there. In this correction, seller to repair leak under the kitchen sink and replace 3 broken roof tiles on the south side wall, right? Let's get into 7E, lender required repairs. All right. Here, neither party owes this by default. The seller don't automatically owe the buyer to fix lender required repairs, and vice versa for the buyer to seller. Unless agreed in writing, neither buyer or seller is obligated to pay for lender required repairs, including termite treatments. It also says contract terminates, earnest money refunded if lender required repairs don't get done. And there's a 5% rule. If lender required repairs cost more than 5% of the sales price, buyer may terminate and get their earnest money back even if the seller agrees to pay. It's in the contract. All right, so keep that in mind. 7F, one of the biggest mistakes I see people all the time have is completion of repairs. All right, how repairs get done in section 7F. Seller complete all repairs before the closing date and gets any required permits. There is a big myth that's absolutely insanely wrong. The contract says the repairs have to be done prior to closing and get all required permits for the repairs. Who can do the work? It's telling you licensed repair persons where a license is required, or commercially engaged in the trade if no license is required. So simply put, it just can't be any old person. If it's license required, they need to have a license, or commercially engaged in the trade. So keep that in mind. Seller must also provide proof of work, payments, and transfer warranties to the buyer at closing, and provide scope of work, what was done. If repairs are not done in time, buyer can use default remedies in paragraph 15. That's one thing. Or extend the closing up to 5 days if necessary for the sellers to complete the repairs. That is part of the contract. Get repair receipts and warranty transfers in writing before closing. Do not take verbal confirmation. We always get situations where, hey, the seller is a contractor. If he's a contractor and he's commercially engaged in trade, yes, he needs to give a receipt. He needs to give warranties. He needs to give all the others, right? Doesn't matter. The contract does not say if the seller or the contractor, they don't have to give it. It must be given. All right, so keep that in mind. 7G, just a heads up, not a guarantee about environmental matters, pretty much. All right, that's all it really contains. 7 Hotel is about residential service contracts, also known as home warranties. Buyer may purchase a home warranty from a licensed provider. If purchased, seller reimburses the buyer at closing up to the dollar amount stated in the blank. So this is saying, okay, Mr. Buyer, Mrs. Buyer, you're going to get a home warranty and the seller is going to reimburse you this dollar amount for that home warranty. Most home warranties cover about 12 to 13 months of coverage. Home warranties are not insurance. They are covering items such as appliances and maybe some plumbing and things of that nature that is outside of the normal catastrophic insurance, such as fires, roof, and things like that with the normal home insurance. This is 100% optional. I do recommend it. And the purchase of a residence contract is optional. Okay, it's very optional. Don't let clients feel pressure into specific home warranty providers. It's their choice. Remember that. 7I. This is new. This is very new. Seller's water disclosure. Now, I took some time. I was reading this. And I was like, okay, hey, this is really good stuff. If there's groundwater rights or surface rights, this is where it's going to be identified to the access to the water may be regulated or restricted. There's 3 options you have to structure the seller's disclosure. What we have is very simple. 1, they received the seller's water disclosure. 2, they haven't received, and within a certain amount of days, they're going to receive it. And 3, it's not required. All right. Now, in El Paso, it's probably not going to be required. It says here, seller is not required to deliver a seller's water disclosure to the buyer because of all of the following are true. A, seller is not aware of a water well on the property. B, seller is not aware of a pond, lake, water, or tank on the property. C, seller is not aware of any certificate of adjudication, certified filing, or permit for surface water rights associated with the property administered by the Texas Commission of Environmental Quality. D, seller is not aware of any groundwater rights to the property have been severed, sold, or leased in whole or part, and the property receives water only from the municipality, the MUD, or Special District Water Supply Corporation, or Private Water Supply Corporation. So most likely in El Paso, we're going to be checking off 3. Only if 5 listed conditions are true. No pond, no lake, no surface water permit, no severed rights, and nothing else is there. That is new. Okay. 8. Section 8, broker-agent relationship disclosure. Plain is if the broker is also a party to the deal, we must disclose. All right. Or they have a parent, child, or entity that owns 10% or trust, they must disclose. An agent buying a listing for themselves or selling to a family member, you must disclose. All right. Disclose. Paragraph 9. Closing date. Simply put, when the deal finishes, what's going to happen? What date's going to finish? And when it closes, what's happened? It's going to be a warranty delete plus some tax statements delivered. And at closing, buyer must pay the sales price in good funds. 10. Possession. 1 or 2 options. Take possession upon closing or in accordance with a written lease. If no written lease, it creates a tenancy in sufferance, a weak, risky legal position for whoever is occupying without a lease, meaning that the seller just keeps on staying there. We have a problem. Okay. Smart devices. 10B. Seller must hand over all access codes or passwords and remove their own personal device access at possession. So pretty good. All right. 11, special provisions. Fact-based information. We cannot add or delete or modify any of the contract provisions here or be practicing law. If attorneys want to write in there, that's fine. If your buyer or seller wants to write in there, that's fine. But agents can't be practicing law. So if you're going to use language inside there, make sure you draft it up in such a way that it doesn't add, delete, or modify the contract. It really is super important that you understand that. 12, get into the settlement stuff. All right. In 12, the first portion of 12 plainly is who's paying what at closing. The first portion, 12A, talks about expenses. The following expenses must be paid prior to closing. That's what it says in 12A. Seller shall pay the following expenses. Seller expenses in 12A1. It talks about all the things as far as existing liens, release of the seller's loan, liability, tax statements, certificates. All right, all these different things in seller in 12A1A. Now in 12A1B, an amount not to exceed blank amount of dollars to be applied towards the buyer's expenses other than the brokerage compensation or contributions in 12. So meaning of what we're talking about, seller concessions. What does the seller contribute to the buyer's closing costs, most likely in that one? And then in 12A2, it defines what is a buyer expense. Has a whole list of things there: appraisal fees, loan application, origination, credit reports. You can just keep on reading. Private mortgage insurance, a bunch of different things. VA funding fee, it always comes down there to VA, FHA mortgage premiums, right? And then when you get into 12B, right? 12B is going to get into broker's compensation. You're going to either check one or two, or maybe even both. I'm not sure. It could be both. But the way this reads, this is where if the seller is going to pay for the buyer broker fee, it will be in 12B1. If the buyer was going to pay for the seller's broker fee, you would put that in 12B2. That's the way it reads now. All right. So there, everything's transparent. Everything's in the contract now, and there's no guessing game whatsoever. And now this is the reason that the 24-1 and the 24-2 has been retired, because everything's inside of the contract. Now, this is not to say broker-to-broker compensation cannot be done, because it still can be done. But in this case, it identifies the seller and buyer who's paying what on the contract. Now, this does not change anything pertaining to any type of agreement that's already previously agreed upon with your buyer rep agreement or listing agreement. So let's say that the seller's only contributing 5 apples to the buyer broker fee, and you're the buyer's agent and you agreed to 7 apples. That buyer's still on the hook for 2 more apples. So just keep that in mind. Everything's negotiable. Everything is up for grabs here. What your fee is, and just keep that in mind. And last but not least, 12C, expense limitations. Expense limitations: if a governmental loan program regulation prohibits the buyer from paying charges or fees, then the amount of any concessions at 12A1B shall be first applied to pay such prohibited expenses, and then to the buyer expenses, but not brokerage compensation or contribution. So any leftover concessions goes to the buyer expenses, but never to the broker's compensation, simply put. All righty. Those are pages 4 through 6. I hope that helps. Until next time.